Hi, my name is Courtney V. Brock. I am the managing attorney for the pro bono unit at the Charlotte Center for Legal Advocacy. And today I'm just going to go through expunction law in North Carolina. Hopefully, by the end of this, you'll get a better understanding of whether or not your criminal record can be expunged or what parts of it can be expunged. And you'll learn a little bit about the Advocacy Center as well. So I'm first going to kind of give you a rundown of what my organization does, who we are, and who we help. Then we'll talk about how to figure out if you're eligible for criminal record expungement. If you are, how you would go about petitioning the court to get that relief. We'll also talk about certificates of relief, which are sort of a lesser form of expungement. And then we'll have some time for questions or just some additional resources that you can access on the last slide. So the Charlotte Center for Legal Advocacy is a local organization here. We serve Mecklenburg County and surrounding areas. Our mission is to pursue justice for those in need. And you can see our vision there as well. Really, we are just here to help people get access to civil legal services. And what I mean by that is, if you were ever charged with a crime and you went into court, you were provided an attorney if you couldn't afford one. That's what happens for criminal cases. However, if you have a civil legal issue, something like somebody sues you or someone takes advantage of you and you want to try to sue them, you're not entitled to an attorney in that situation. In order to access those rights, you need to hire an attorney. And the Advocacy Center is able to provide some of those services to people who can't afford a civil legal attorney. We serve about 10,000 individuals a year in Mecklenburg. And in our region, there are actually more than 300,000 people who are eligible for our services. So if you do reach out to us, it may be that you have one of the attorneys in our office helping you, but we also use pro bono attorneys. That's attorneys who will work for free for our organization. Those are called pro bono attorneys, and they also help us kind of meet this need because we don't have enough staff to serve everybody who's eligible for our services. We have several programs at the Advocacy Center. Our immigrant justice program helps individuals regardless of their documentation status. We do removal defense work in that program. We also assist families in planning for potential family separation due to detainment or deportation. Our family support and healthcare group focuses mainly on getting people access to benefits, public benefits, including food access, so food stamps, SNAP benefits, as well as healthcare. So healthcare navigation services are available through the Advocacy Center, at least through August. We also have a low-income taxpayer clinic. This is geared towards people who owe the IRS money on past taxes and need some assistance negotiating that with the IRS. Our legal services for the elderly program helps prepare end-of-life documents for Mecklenburg County residents over the age of 60. Our General Consumer Protection Division helps people who have been victims of unfair and deceptive trade practices or people who are looking to get assistance with home preservation, so defending against foreclosure or maybe filing for bankruptcy. Our Veterans Legal Services project helps local veterans, mostly focusing on veterans who are at risk of or experiencing homelessness. And our Community Empowerment Project is the division that assists with criminal record expungement and driver's license restoration and other reentry services. So let's talk a little bit about that. In North Carolina, you'll hear me say expunction or expungement. They mean exactly the same thing. Most states, I think, and most people know it as expungement, but expunction means the same thing, tomato, tomato. I'll probably use them interchangeably. So hopefully that won't be too confusing. But what that is the destruction of a criminal record by court order. It is intended to restore the individual in the eyes of the law to the status they occupied before the criminal record existed. So basically, it's hitting reset. It's as if it never happened. That is the purpose of expungement law. That's these statutes are supposed to do. Anyone who has ever been criminal justice system involved knows what's on this slide. Once you have a criminal charge on your record, it makes it really hard to get stable employment or housing. You lose access to things like occupational licenses and educational opportunities. So the purpose of expungement is to help people who have been criminal justice involved participate in society again in a meaningful way. And the statistics show that employers and landlords, they do look at criminal records, and it does affect whether or not they're willing to give someone an opportunity. So I'm going to talk through the rules of how to get these criminal records expunged, how to get back to a place where you don't have every employer just rejecting your application because you said you got arrested one time. So in North Carolina, before 2011, there was really very little that you could do about your criminal records. But since then, there have actually been 16 laws passed with bipartisan support. The three that we're going to be talking about today cover most charges. There are other expungement laws that are specific to people's situations. For example, there's one for victims of trafficking. We don't see a lot of those clients, and if you are in that situation, there are organizations that you can reach out to. You can always call us and we can help with a referral. So the three most common ones that we see are dismissals and acquittals, raise the age convictions, and nonviolent adult convictions. And like I said, some other relief is available when you're not eligible under any of these statutes, referred to as certificates of relief. We'll talk about those at the end. I think the first thing to understand is the life cycle of a criminal case. And if you've been ever charged with a crime, you probably have some familiarity with this. So the first thing that happens is that someone is charged. They are served with that charge, meaning they first come into contact and learn of it either by citation. So you get pulled over by a cop and they give you that little slip of paper. Summons, sometimes a sheriff will show up at your door and give you paperwork saying you have to come to court and answer for this criminal charge, or by arrest. That's probably the most common one that people are familiar with. The next thing that happens is you go to court, sometimes a bunch of times. And if you miss court, the judge can order your arrest if you're not there at your court date. That would mean that your case is going to remain pending and you're going to have to go back to court in order to resolve it. At some point in one of those court appearances, the district attorney is probably going to make a plea offer, and then the person can either plead not guilty and demand a trial or plead guilty and have their case resolved. So resolution is how your case gets out of court, how you stop having to come to court, more or less. This can happen in a bunch of different ways. So like I said, someone can plead guilty and then they're sentenced either with a fine or probation, or maybe they serve an active sentence. A district attorney can dismiss the charge. Maybe the victim never comes to court, or they realize that they don't have enough evidence, or they realize that it wasn't the person that they charged. In that case, they would or should dismiss the case, and you wouldn't have to come back to court after that. And if you're sentenced, if you plead or if you're found guilty and you're sentenced, then that sentence is going to vary, and it's going to mean that there are some things that happen after the conviction or after that last time in court when you enter a plea or are found guilty. So after conviction, your probation could be revoked, extended, or terminated. If you had an active sentence, you're going to be put on parole or post-release supervision, as it's referred to in North Carolina. And then once that sentence is complete and your restitution is paid, then you might be eligible for expungement. So whether or not you're eligible is going to be based on a variety of factors. This is where things kind of get confusing and complicated, and I'm going to walk through each one of these hopefully in a way that's fairly digestible. The first one that we're going to talk about is disposition, meaning how the case was disposed. What happened that meant you didn't have to come back to court anymore? For the purposes of expungement, if the case is not yet disposed, it's not going to be eligible for expungement, pretty much no matter what. If you were convicted, either at trial or by entering a guilty plea, it's going to depend on some or all of those factors on that previous slide. And if it was a dismissal or acquittal, so if either the district attorney dismissed the charge or you pled not guilty, you had a trial, and you were found not guilty, then it's always going to be eligible. And we'll talk about the specific rules for each of these categories. So when I say not yet disposed, I mean that the case is still pending. So you might know this because the case has a future court date on it, or you missed a court date and there's an outstanding order for arrest or a failure to appear. Also, cases that were voluntarily dismissed with leave, if you see that on a criminal record, that's going to mean the case is still pending as well. It means the district attorney can kind of bring that case back from the dead whenever they feel like it. There are ways to resolve those charges, especially if they're old. Sometimes you can just go to the DA's office and ask if they'll dismiss it, especially in Mecklenburg if it's an old charge and it's a minor one. They may just dismiss it for you and then you can get it expunged, but it has to be dismissed without leave, not with leave. And then the last category of not yet disposed are unserved charges. Means that there was a warrant out there at some point and they never served it on you. The sheriff never showed up at your house and gave you the paperwork. And so that charge is going to be treated as still pending. Dismissals and acquittals. The disposition on these is going to be one of the things listed here. So if you're found not guilty, if the case was voluntarily dismissed without leave, if you were part of either a deferred prosecution or conditional discharge negotiation with the DA's office, meaning you probably served some time for probation, but you completed your probation and then the charge was dismissed afterwards, that is going to be eligible for expungement. Also, if your case says never to be served or no probable cause, those are also treated as dismissals and would be eligible for expungement. So here are the rules for dismissals and acquittals. They are always eligible and they're almost always mandatory, meaning that the judge doesn't have any ability to say, oh, I don't feel like giving you the expungement, so I'm not going to. They have to give you the expungement in these cases. There's no waiting period, meaning that the day that your case is expunged, you can petition the court to get it off your record. I'm sorry, the day that the case is dismissed, you can petition the court to get it expunged off your record. There's no limit on the number of charges you can expunge or the times that you can petition for expungement. So if you petition the court today to expunge dismissals that you've had previously, and then you get charged again and that case gets dismissed after today, you can still expunge that charge. And there's no disqualifications based on prior convictions or other charges. If you have pending charges right now, you can still get your old charges that were dismissed or that were acquittals removed from your record. Right now, there is also automatic expungement for cases from 2019 until today, but they do take a while because the administrative office of the courts is working through those. So if you remember an old charge from 2019 or on and you can't find it in the system, it's probably because it was automatically expunged. If you have a case that gets dismissed tomorrow, it's going to take probably 180 days or so to get that case off your record without a petition to the court, but it will eventually automatically come off. If it was a dismissal, that's mandatory. So for convictions, like I said, it's going to depend on a lot of factors. And when I say conviction, the disposition is going to be one of these things listed here. So either you pled guilty, you were found guilty at trial, you pled responsible. This is applicable for infractions. So those are usually traffic offenses that are really low level. You would have pled responsible instead of pleading guilty. This also includes prayers for judgment continued. You may have one of these if you went into court and you said, well, I admit to doing this, but you weren't actually sentenced. This happens a lot in traffic cases because it avoids having your charge reported to the Division of Motor Vehicles, so you don't get increased points on your driver's license. And those are also known as PJCs. So the first thing we're going to talk about is the severity. So the worse a crime is, the less likely it is going to be eligible for expungement. In North Carolina, the most serious crimes are felonies, A through G being the most serious ones, and then the H or I felonies being the lesser. Less serious than that are misdemeanors, and misdemeanors are classified from 3 through A1. So A1 are going to be your most serious misdemeanors, and then class 3 are going to be your least serious misdemeanors. And then there are also traffic infractions. Those are going to be the least serious of any reason that you've come into court before. Then we're going to look at age at the time of offense. So if you were 16 or 17 when this crime occurred, you're considered a youthful offender. So we'll talk about that in a second. If you're 18 or over when you committed the crime, that's going to be considered an adult conviction, and there's different rules for that. So when I say raise the age, I'm referring to the shorthand term for a law that was passed in 2019, which raised the age that a person is charged as an adult from 16 to 18. They also passed this law to make it more fair. Anybody who prior to that law being passed was 16 or 17 when they committed a crime and were charged as an adult can expunge that charge the same as if they had been charged in juvenile court. However, this relief is only available for Class H and I felonies and any misdemeanor with the exception of sexual battery. So if you have an H or I felony or a misdemeanor except for sexual battery that occurred when you were 16 or 17, it's probably going to be eligible to come off your record under this law. So long as you have completed your sentence and paid your restitution, these expungements are going to be mandatory. Again, the judge can't just decide because he's having a bad day that he's not going to give you this expungement. The one big caveat is that motor vehicle offenses are not eligible under this statute. We know a motor vehicle offense when the statute starts with Chapter 20. So Chapter 20 offenses like DWIs are not going to be eligible under this statute. For adult convictions, the legislature has decided that only nonviolent convictions are eligible, and they've defined what nonviolent means. We'll talk about that in a little bit here, but again, the thing to know is these are things that happened when you were 18 or older, and you're going to look at severity, how many charges you're looking to get off your record, when they occurred, whether the waiting time has passed, and what other convictions you have on your record. So for misdemeanor convictions, you can only expunge class 1 through 3 misdemeanors. Anything that's an A1 or any class 1 through 3 that involves assault are not going to be eligible for expungement. Those are also going to be disqualifying convictions, and we'll get to that in a second. You also have to complete a waiting period. That waiting period is going to start at the end of when your sentence was completed. So the day that you were done with probation, that's when the waiting period is going to start. And if you're expunging one misdemeanor, you have to wait 5 years from that date. If you're expunging 2 or more, you have to wait 7 years. You also cannot have any disqualifying convictions, which we'll talk about in a minute, and you can't have any pending non-traffic charges. So like I said, Chapter 20, if you have a pending speeding ticket or even a pending DWI, you can still petition the court. But if you have a pending misdemeanor larceny, you're not going to be able to get any adult convictions expunged. Those rules both apply still for felony convictions, that you can't have disqualifying convictions and you can't have pending non-traffic charges. For felonies, most H&I felonies are going to be eligible for expungement. Those are the lower level, less serious felonies. For timing, you can't have any misdemeanor convictions for 5 years before you petition the court, and you can't have any felony convictions for the applicable waiting period, which we'll get to in a second here. The thing to remember here is that it has to be a conviction in the waiting period in order to restart the clock. So if you get charged with something and it's dismissed in the years leading up to petitioning the court for expungement, that's not going to affect your eligibility. Now, if you're petitioning the court to expunge one breaking or entering felony, you're going to need to wait 15 years from the completion of that sentence. Any other felony, if you're just expunging one, you're going to have to wait 10 years. If you're expunging 2 or 3 felonies, you'll have to wait 20 years from the most recent sentence completion. And all the incident dates for 2 or 3 felonies have to be within 24 months of each other. Same thing, this begins when the sentence for the most recent felony has been completed. And these are the disqualifying convictions I was talking about. So if you have a conviction for any one of these charges, it's going to mean that you can't get any adult convictions taken off your record. Now, it's not going to affect your eligibility for youthful convictions, so anything that happened when you were 16 or 17. And it's also not going to affect your ability to get dismissals and acquittals taken off of your record. The ones in bold here are the ones we see most frequently, which is why I've bolded them. But you will want to look at this list and see if you have any of those convictions before you can proceed at all with expunging adult charges. Here's something to remember too. So when we talk about 2 or 3 felonies being eligible for expungement, multiple convictions that occur in the same court session are treated as one conviction. So if you went into court and you had a bunch of different charges and the DA said, all right, well, if you plead to these 3, we'll dismiss the rest, and you accepted that plea offer, those 3 charges actually only count as one when we're talking about expungement. So that is just something to note. The other thing to note is that you really only get one chance to expunge all of your misdemeanors and one chance to expunge all of your felonies. So you want to make sure that you have all your charges listed out when you are going to petition the court, which we'll talk about in a second. All petitions must be filed within 120 days of each other across the state. So if you have charges in Mecklenburg and in Cabarrus that are all eligible as convictions, you have to file them all at the same time. And again, this is only for adult convictions. It's not for 16 and 17-year-old convictions, and it's not for dismissals or acquittals. The other big thing to know is that you have to pay your restitution before you can expunge any charge. This is youthful convictions and adult convictions. You may have a lot of fees and fines left on a case. Those are not going to affect whether or not you're eligible for expungement. So probation supervision fees or court fees or attorney's fees, those all don't affect your expungement. It's only restitution or civil judgments representing restitution. So if you went into court for one last time on your probation and the judge said, I'll convert all restitution to a civil judgment, that all still has to get paid before you can expunge your criminal charge. And speaking of probation violations, these are not going to be eligible on their own. When you look at your criminal record, you'll see that they're on there. They're not going to be eligible on their own, but if the charge that you were placed on probation for gets expunged, then the probation violation will also come off your record. For driving offenses, these are technically going to be eligible for expungement, but we proceed with a lot of caution on these. So impaired driving offenses or DWIs, those unfortunately are not going to be expungible. Um, they can't be expunged, but also they're not disqualifying. So if you have a DWI, you can still get anything else off your record, but you're not going to be able to get that one off under current law. The other thing to know is that a lot of times when you get pulled over, the way that they write out all the charges, they go under one case number. If not all of the charges are eligible under that case number, sometimes the DMV's system will mess up and they'll accidentally suspend your license without you having done anything wrong. If this happens, it's actually an easy way to fix it, but we don't want to see anybody's license get suspended. And for the most part, I know these aren't usually the charges that are holding you up and getting employment and and housing. So we kind of don't touch them generally if we see that it might cause this error. With regard to out of state convictions, so anything that happened not in North Carolina or that happened in federal court, um, these charges are not going to be eligible for any kind of relief through the North Carolina courts system. Out of state or federal charges could be disqualifying as well. Um, and federal charges are almost never going to be eligible for any kind of relief, unfortunately. What we tell clients and what you should do if you have any out of state convictions is to seek local counsel. So if you have a South Carolina charge that you're wondering if you can get expunged, you're going to need to call a South Carolina attorney or check to see what kinds of resources South Carolina's court system have available for people looking to expunge their records. And just to go over this kind of one last time, because I know it's a lot of rules and it's pretty confusing. This is like boiled way down. If you have a dismissal or you are found not guilty, that's going to be eligible for expungement. If you have something that happened when you were 16 or 17, so long as it's not a serious felony, that's going to be eligible. And if you have an adult conviction, you're going to have to complete a waiting period and you're going to have to make sure you don't have any of those disqualifying convictions. But those will be eligible after those waiting periods. For misdemeanors, it's going to be between 5 and 7 years. For felonies, it's going to be between 10 and 20 years. Now, the way that we actually get these things removed from the record is by petitioning the court. What I mean when I say petitioning is you basically fill out a form and you give it to the clerk, and it goes through a process that removes the record from your record, removes the charge from your record. In North Carolina, most counties now have transitioned to electronic systems. All of their records are going to be available through Portal. Uh, this little smart search function here is something that you can use to look up your charges from the 73 counties that have moved over to e-filing. There are still some counties that are not on e-filing yet, and you won't be able to see your charges from those counties. But for the most part, you can look in Portal and find your cases, either searching by case number if you know it, or by your name. It is not great at pulling all of the charges under your name, especially if you have a really common name or if you have a really unique name and somebody misspelled it in the system. So we don't really use this to get complete records. We only really use it when we know exactly what case number we're looking for. But I'll get into a little bit how you can make sure you're getting a good record in a second here. This is what an expungement petition looks like. And there's several different petitions, forms, I should say, that you'll need to fill out depending on what kind of case you're trying to expunge. All of these forms are available online, and you're going to complete all of these fields. So this is a fillable PDF. You can also print it out and handwrite it in if that's easier for you. If you're filing in an e-file county, you can create an account on the AOC website and then file electronically, or you can bring it to the clerk's office and they will assist you in filing it. And these are links to all the forms. We'll maybe post the slideshow or post a link to access those forms. But the best way to get assistance is to visit the Self-Serve Center in the Mecklenburg County Courthouse. This is a unique feature of Mecklenburg County. Not everybody in North Carolina has access to a self-serve center, but the staff here help people who are representing themselves on some civil matters like expungements. We call that representing yourself pro se. The self-serve center is located on the third floor of the Mecklenburg County Courthouse. If you have your criminal record, like if you had an employer run your background for you and they gave you a copy of it, you should bring it to the self-serve center. However, they will direct you on how to get a criminal record from the clerk's office if you don't have it with you. The thing to know is that they're only going to be able to give you your criminal record from the county that you're in. So you'll only be getting your Mecklenburg County charges. If you have anything in any other counties, they're not going to be able to pull those up. The other way to get help with petitioning to the court, oh, sorry about that, is to sign up for notifications for when an expungement clinic is open. So the Advocacy Center holds expungement clinics at least twice a year. We pull your criminal record for you. We determine what charges are eligible for expungement, and then we fill out those petitions for you so that you can file them to yourself. If you have lots of convictions in different counties and you're low income, we may even be able to take your case for full representation, meaning that a lawyer will do it all for you. And then the last way to get help petitioning the court is to just hire an attorney. Most criminal defense attorneys also do criminal record expungements. They can be expensive. Our clinics are free, but if you need additional assistance, we're only going to be able to assist you if you're low income. So expungement petitions can take a long time to process, especially conviction petitions. So the process along the bottom is about conviction petitions. They can take 6 to 12 months to process, depending on the county. We recommend that people check in with the clerk's office every 60 days or so. The first thing they're gonna ask you is, what's your case number? So have that ready if you're calling the clerk's office to check in on your case. But this process, I'm not going to go through every step. This is the process that a petition has to go through for a conviction, which is why it sometimes takes a whole year to get these petitions processed. But it's also why checking in with the clerk's office is important, because sometimes a petition will get stuck along one of these stages and it won't move until someone reaches out to the clerk's office and says, hey, move my petition. So, certificates of relief are sort of expungement light, is what we call them. It's not going to remove the charge from your record, but it may help with getting employment, getting housing, and it will definitely help with getting any occupational licenses that are issued by the state. Mostly we see this with people who are trying to get into nursing. So if you need to get clinical hours for nursing and you have a criminal charge on your record that can't come off, you can get a certificate of relief potentially. And that will mean that the state licensing board cannot deny your certificate or your license because of the criminal charge. More charges are eligible under the statute than are eligible under the adult conviction statute. You can have any misdemeanor offense can get a certificate of relief, and any H or I felony, with the caveat that you can't have more than 3 H or I felony convictions. The waiting period is also a lot shorter than it is for those expungement statutes. It just has to be 12 months from completion of your most recent sentence. And it's sort of like a letter of recommendation from the court saying, this person did everything they were supposed to do, and it's been 12 months since they've had any other convictions, and they should be entitled to some relief from having this criminal record. What we recommend is that anytime you're filling out an application for housing or for employment that asks if you have a criminal conviction, you answer honestly, of course, and then you attach your certificate of relief. Um, which reminds me, I just want to talk really quickly about a lot of the frequently asked questions we get from our expungement clients, which you're probably wondering about. I don't have a slide for this. I apologize, but maybe I'll add one in later. A lot of people want to know afterwards who can see my charges that were expunged. So the only people that should be able to see your charges once they're expunged are DA's offices, clerks upon request, and judges. So only people in the court system who are requesting to see expunged records are able to see them. Employers shouldn't be able to see them. Landlords should not be able to see them. Anyone who runs a criminal background check on you that's not a part of the court system won't be able to see them. The other question that we get a lot is, when do I have to tell people about them? And just remember, all the way back at the beginning of the presentation, you were supposed to be restored to the status you were before you ever got the criminal charge. You don't ever have to say anything about an expunged charge. Even if you get called into court and they put you up on the stand and they ask about your criminal convictions or arrests, you don't have to say anything about any of your expunged charges. Um, I'm going to put up this last slide here, which has some resources. So our website can give you any information on any of those services I mentioned at the top. You can always call our general intake line to see if you're eligible for our services or if you have a legal problem that we can help with. And then you can sign up for clinic notification at the link there, which we'll also include on the website. Clinics do fill up really quickly, so if you get that notification, sign up as soon as possible. And it seems that text notification works a lot better, so consent to texting when you sign up to get your notifications. The Self-Serve Center's website is here as well. They have resources on the website, and then they have people at the Self-Serve Center who can help you with your expungement petitions, especially with those dismissal and acquittal petitions. They are open Monday through Friday, 8:30 to 4:30. And if you're looking to hire an attorney, if you had a criminal defense attorney who is not a public defender represent you on a criminal charge, they likely offer expungement services. So if you liked that attorney, you can probably go back to them and ask them for assistance, or you can check the lawyer referral service, which is run through the North Carolina Bar Association. You can search in there and find a local attorney to help you out with any of your expungement needs. I hope this has been informative for anybody, for everybody. Anybody who has any questions can reach out to our office, or head to the self-serve center next time you're at the courthouse. And that's all I have for today. If Shelby or library staff have any questions, you can chime in too.
And I'll just add as well, the Mecklenburg Bar Association, we do also offer a lawyer referral service. The North Carolina Bar Association's referral service is a little bit bigger than ours, but ours includes only local attorneys. So if you ever do need to find a referral here locally, that is a resource that is also available. The information that Courtney included for the Charlotte Center for Legal Advocacy, the Self-Serve Center, and the North Carolina Bar Association, all of that's included on our website as well on our public resources page, along with numerous other resources, local and state. So we hope you'll take a moment to check that out if you ever need to find something.
I have one last thing I forgot to mention, and I'm going to add a slide to it too, so it'll be online. I always forget this part. So, when your record gets expunged, the clerk's office is going to notify all the statewide agencies, and your records will get removed from there. There are also private organizations that maintain databases with your criminal charges on them. And in order to get the records removed from there, you need to submit your completed petitions to a clearinghouse website. So, there's this organization called the Foundation for Continuing Justice. All you have to do is take your PDF, your file that you get back from the clerk's office and upload it to a website, and they'll make sure that any records that are not maintained in the state system get pulled down. And that's a really important step because a lot of times employers and landlords are using private services to run criminal background checks and not the state system. I will make sure that that's included in a slide because that's a really important one. Sorry, I knew I was forgetting something.
Well, we want to thank you for providing such detailed and informative information for us. I know this is a very confusing topic for a lot of people, and it's even confusing for the attorneys who do it. So we are very appreciative of your time and all this very wonderful information.
Thank you guys for having me.